Hello, law students and legal practitioners. Today, we will analyze the case of Garcia versus Commission on Elections, GR number 111511, decided by the Supreme Court on October 5, 1993. Let's begin. Here are the legal doctrines of the case. The power of recall is an incident of the people's sovereignty and is constitutionally recognized as a mechanism to remove elective local officials who have lost the confidence of the electorate. The Constitution does not prescribe a specific mode of initiating recall, nor does it prohibit Congress from providing multiple modes of initiating recall proceedings. Congress, pursuant to its constitutional mandate under Article 10, Section 3 of the 1987 Constitution, has the authority to determine effective mechanisms of recall, including allowing a Preparatory Recall Assembly, PRA, to initiate recall proceedings. The choice of such mechanisms lies within the discretion of the legislature and is not subject to judicial interference absent a clear constitutional prohibition. A resolution of recall adopted by a Preparatory Recall Assembly does not itself affect the recall of an elective official. It merely initiates the recall process. Recall becomes effective only upon the election and proclamation of a successor, or upon the reaffirmation of confidence by the electorate in a recall election, as explicitly provided by law. The requirement of notice to all members of the Preparatory Recall Assembly is an indispensable element of due process. Failure to notify all members fatally vitiates the validity of the recall resolution, as it nullifies the representative character and collective judgment of the Assembly. Loss of confidence, as a ground for recall, is a political question. Courts will not inquire into the substantive reasons motivating the electorate or their representatives in exercising the recall power, as such matters fall within the sovereign discretion of the people. 1. Here are the relevant facts of the case. Enrique T. Garcia was elected governor of Bataan in the May 11, 1992 elections. In the early morning of July 2, 1993, mayors, vice mayors, and members of the Sangguniang Bayan of Bataan's municipalities convened at the Bagak Town Plaza and constituted themselves as a Preparatory Recall Assembly, PRA, to initiate the recall of Governor Garcia on the ground of loss of confidence. The PRA adopted Resolution No. 1 calling for Garcia's recall. While the resolution bore 146 names, only 80 members signed it, and only 74 signatures were found genuine. The PRA's total membership was 144, making 73 the required majority. Despite the numerical sufficiency, it was admitted that not all PRA members were notified of the meeting. Notices were selectively sent only to those politically aligned with the recall proponents. Petitioners challenged the resolution before the COMELEC, arguing violations of Section 70 of the Local Government Code and unconstitutional deprivation of due process and equal protection. The COMELEC dismissed the challenge and scheduled a recall election. Petitioners then elevated the matter to the Supreme Court through a petition for certiorari and prohibition. While the initial resolution was voided by the court due to lack of notice, a second PRA meeting was later conducted with proper notice, resulting in another recall resolution. Petitioners persisted in challenging the constitutionality of Section 70 of RA 7160 insofar as it allows a PRA to initiate recall proceedings. Issue 1. Whether Section 70 of the Local Government Code of 1991, which allows a Preparatory Recall Assembly to initiate recall proceedings, is unconstitutional. No. Section 70 of RA 7160 is constitutional. The Constitution mandates Congress to provide for effective mechanisms of recall but does not specify how recall should be initiated. Congress is therefore vested with discretion to determine the appropriate modes of initiation, including indirect initiation through elected representatives. The PRA acts as a representative body of the people. Initiation by the PRA is not usurpation of popular sovereignty but a permissible indirect exercise thereof. The recall itself is consummated only by the electorate in a recall election, preserving the people's ultimate sovereign authority. Issue 2. Whether a PRA recall resolution amounts to the actual recall of an elected official. No. A PRA resolution merely initiates the recall process. Section 72 of the Local Government Code expressly provides that recall becomes effective only upon the election and proclamation of a successor. Until such time, the official remains in office, subject to the outcome of the recall election. Governor Garcia was not removed from office by the PRA resolution. He remained governor pending the recall election, and the electorate retained full authority either to reaffirm or withdraw confidence through the ballot. Issue 3. Whether Section 70 of RA 7160 violates the Equal Protection Clause by allegedly favoring political majorities. No, there is no violation of equal protection. The composition of the PRA is politically neutral by law and includes all elective local officials regardless of party affiliation. The sole statutory ground for recall is loss of confidence of the people, not political opposition. Possible abuse of the recall process by political actors does not render the law unconstitutional. The mere possibility of abuse is insufficient to invalidate an otherwise lawful grant of power. Thank you for listening and happy learning. Please don't forget to subscribe to the Legal Shepherd PH YouTube channel and click the notification bell to stay updated on newly uploaded cases and jurisprudence. See you again for our next case discussions.